All rise. The Court of Appeals, Division 1 is now in session.
Okay, thank you. Please be seated. Welcome to the Arizona Court of Appeals. This is case number CV130244, Pendergrass versus Arizona State Retirement System. For the parties' information, these proceedings are being recorded, and with any luck, you will be able to see yourself on YouTube and have your 15 minutes of fame in a couple of weeks, assuming that the equipment works. As you approach the podium, please identify yourself and who you represent. The podium has a clock on it, and that will indicate how much time you have left. Each side will have 20 minutes. Appellant, you may reserve a portion of your time for rebuttal, and if you'll tell us how much time you would like to reserve, we'll try not to horn in on that time as well. So, we have read the briefs, reviewed relevant portions of the record, and conferenced the case this morning prior to argument. So with that in mind, you may begin.
Good morning, judges. I'm Jyoti Belgian on behalf of the appellant, Arizona State Retirement System. The Arizona State Retirement System is requesting that this court overturn and reverse the Superior Court's decision. Central to this case is whether the service purchase program is protected by Article 29 of the Arizona Constitution before a transaction occurs. Central to that issue is whether Article 29 and the term retirement benefit is construed in a narrow manner to limit it to deferred compensation, or whether it's construed broadly to encompass a whole bundle of retirement rights that are offered by the retirement system. The construction should be narrow, and these are the reasons why. The Arizona State Retirement System, like the other state retirement systems, administers retirement benefits and also operates ancillary programs. The retirement benefits, the core retirement benefits, are what most people are familiar with, a pension benefit that a government employee will receive at the end of their career, a monthly payment. If a person chooses not to retire, they'll receive that pension form instead in another form. If they choose to forfeit and receive a refund of contributions, they'll receive it as a lump sum payment before retirement age, or if they pass away before retirement, they'll receive it as survivor benefits. But essentially, those three items are all deferred compensation in three different forms. What the retirement system also operates are a number of ancillary programs, and examples of those are a long-term disability program. For Arizona State Retirement System, it is a pure long-term disability plan. For Public Safety Retirement System, it is an actual disability pension. Another plan that's operated is the Retiree Health Insurance Program. Also, are optional defined contribution plans that are offered by the ASRS. Now, ASRS used to offer a deferred retirement optional program. That program was repealed by laws 2006, but Public Safety Retirement System still offers a deferred retirement optional program.
At the time that the optional deferred program was appealed in 76?
2006, Your Honor.
Excuse me. Were there any claims that breached employment contracts at that time?
No, Your Honor, there were not.
Okay. So I guess there was no claim made then that was actually a vested pension interest.
Your Honor, that's correct.
Thank you.
And to that point, the Public Safety Retirement Drop Program that is still in statute was closed by laws 2011 to new participants effective January 1st, 2012. I can't comment on whether there were any claims related to that. But in addition to those programs, Arizona Department of Administration also administers a retiree health insurance program and Arizona Deferred Compensation Plan available to state employees. These programs are all similar to the service purchase program. They're ancillary to the core retirement benefit that the retirement system offers. Therefore, this case cannot be considered in isolation for only the service purchase program. These other programs have to be considered because the analysis will be identical for them.
So what you're saying is if we were to come out and say, you betcha, the Pendergrass assessment interpretation is correct, then it would effectively bind in all these different programs you're talking about into the same contractual pot?
Yes, Your Honor.
Thank you.
And if I could quickly expand on that, the reason is if the service purchase program vests upon employment and is a contractual right upon employment and a protected retirement benefit upon employment, then the same analysis has to provide for those other ancillary programs. They can't be differentiated in any manner. Now,
But your point is that that if Ms. Pendergast had elected to buy the service credits back before the legislature amended the latest amendment, and she had paid the money, her rights would have vested at that point?
yes, Your Honor, that's exactly the retirement system's position, that upon payment for the service purchase, it becomes a contract, a binding contract, a vested right, and a protected constitutional right.
But it's actually contracted for under the provision of statute. It's not a part of the employment contract originally entered into, correct? It's an addendum. It's an ancillary agreement. It's something that subsequently was entered into between the contracting parties.
Your Honor, the position that the retirement system is taking is that it's an ancillary program and is basically the policy of the legislature and subject to change prospectively.
But I guess my question then, and just maybe I'm beating this to death, and I certainly don't mean to, you're not saying that by entering into this ancillary program, it goes back and modifies the original employment contract?
No, Your Honor, I'm not.
So it is simply a secondary agreement. These are my definitions. I don't expect you to necessarily accept them the way I'm saying them, but in generally speaking, this is something that is independently contracted for, not something that is part of the employment process per se.
That's correct, Your Honor.
Thank you.
Now, the difference between a core retirement benefit and an ancillary program is the core retirement benefit applies to every full-time government employee. It's mandatory. It commences upon employment, versus an ancillary program, which is optional, sometimes doesn't even apply to the full retirement population, and almost always, and if not at least frequently, requires some sort of election to participate. So, for example, to participate in the retiree health insurance program, a retired member would have to indicate that they're interested in participating. Now, the Ezell Court concluded that retirement benefits were contractual upon employment invested at that time. And the reason the court had to conclude that is if the employment was not consideration for a pension payment, the post-career monthly income, then they would be a gift and unconstitutional, and that would invalidate the entire retirement system. That's not the case for these ancillary programs because there's additional consideration provided. In the instance of retiree health insurance, the employee our retired member is providing a monthly premium. In the instance of the deferred retirement optional program, the employee is agreeing to defer receiving the retirement benefit, the monthly pension, and instead receive at the end of that time period a lump sum payment with interest. Therefore, for those programs, employment is not the consideration. There are other items that should be identified as consideration, and for the service purchase program, the payment to the trust fund for the service is the consideration. Now, the reason this position is justified is because, number one, Arizona case law, all the cases that exist in Arizona have all been focused on protecting that core retirement benefit, the monthly pension and how it's calculated, a refund, and survivor benefits, and that's the member's right to the survivor benefit, not the beneficiary. Article 29, when it was adopted, there was a ballot pamphlet provided. There was no indication in that material that there was the intent of the voters to provide protection to those ancillary programs. In fact, the overwhelming concern represented by the groups that provided materials in that pamphlet was that they were concerned that the legislature would sweep funds from the retirement trust fund, and then there would not be adequate funds to pay for that core retirement benefit, the monthly pension, when people actually retired. And it was actually mentioned in that material that 14 states had already done that for other trust funds.
Counsel, I want to go back to something you said earlier. I think I understand your position that you're saying it's in your view, this should be narrowly construed. It should be focused on whether this affects the benefit or not that's paid, ultimately paid. It seems like in this case what the issue is the timing of the taking of the benefit. And you still believe that's an ancillary opportunity or benefit as opposed to a retirement benefits protected by the Constitution?
Yes, Your Honor, I do. I believe that those ancillary programs represent the policy of the legislature and serve different purposes. And I believe that PROXA supports the position that those programs are policies and subject to revision prospectively, assuming that someone hasn't done something to vest their right in that program. And for that, on that very point, the original purpose of the program may become outdated, and it's the right of the legislature to determine whether the purpose of the program still exists. So for the example of retiree health insurance, the legislature may determine that there are other resources available to retirees and that the Arizona State Retirement System doesn't need to administer retiree health insurance program. For example, the Affordable Health Care Act may provide feasible options. For the Deferred Retirement Optional Program, one of the main reasons it was repealed from the ASRS and closed off for the PSPRS people is because the very purpose of the drop was to save money from the trust fund. And it was actually costing the trust fund more money because the interest being paid on these amounts was more than the trust fund could earn. And finally, with service purchase, I do believe it's the right of the legislature to determine that the purpose of the service purchase program no longer serves the state. So originally it was giving the people the ability to buy other government employment. Well, the legislature may determine that the purpose of a public retirement system in Arizona is to provide benefits for earned employment, earned service, and not the valid purpose of a retirement service to be selling service for 10 years, 20 years, or even 30 years. In analyzing whether it's a vested right or a contractual right or constitutional right, I think a threshold question is, what is the distinction between an individual who completed the purchase and an individual who didn't? We all agree that the individual employee who actually completed the purchase absolutely has a protected retirement benefit right to the service that was purchased. They also have a contractual right. They accepted the offer of the contract, all material terms were addressed, and performance was completed by payment. Also, with vested rights, the employee who completed the purchase did everything necessary to vest their right. And therefore, there is a valid legal distinction between the employee who completed the purchase and the employee that didn't. And to conclude that they're the same is just not a rational legal conclusion. I have 7 minutes left, so I'll reserve that, if that's okay.
Yes, you may. Thank you.
May it please the court, my name is Adam Lang, and I represent appellee plaintiff Bonnie Pendergast. In 1984, 30 years ago, Ms. Pendergast decided to be part of the public education system. She has taught for 30 years, teaching over 2,000 students in both Minnesota and Arizona. She has loved teaching those kids, but it has come time at the end of her career to consider retiring. Ms. Pendergast, like all ASRS members, had a contract with the state for retirement benefits. Ms. Pendergast lived up to that end of the bargain, and she wanted the state to live up to theirs. Unfortunately, on the eve of retirement, they pulled the rug out underneath her. Had the SRS allowed her to purchase all 9.89 years of her service credit, Ms. Pendergast would have been able to retire in December, a month ago. Now, she's forced to either work longer or get paid less.
So she could have chosen to purchase those credits a couple of times, well, I mean, some time earlier, and secured her right under the existing law to purchase whatever credits she was entitled to, but she didn't like the price,
Well,
apparently.
Your Honor, it's more than just that. She wanted to know when she should retire. She wanted to plan for retirement, and the ASRS has the ability to ask them over and over again, hey, how much would it cost this time? How about that time? And there was no reason for her to do so at that point in time, because she wasn't at retirement at that point, so she was trying to explore her options. And when you have the right under 38743 to purchase unlimited service credit when you so choose to, there's no reason to go ahead and necessarily do it right away. She could wait because she has the right, the vested right to do so.
Do you also think that, I mean, in the years that have passed since she became a member, the method by which the service credit is, the cost is calculated has changed?
Yes, Your Honor.
Do you think that's unconstitutional?
I think there's a possibility that is unconstitutional, Your Honor. I mean, that's not why we're here today. She wanted to be able to purchase it at the price they were giving her. They wanted that right to do so. But is it possible that it's unconstitutional? It could be.
Well, but they changed it, and that change applies even if she was able to purchase all of her, the 9+ years she wants to pay. The manner in which that cost is calculated has changed since she became a member, but you don't allege that was unconstitutional. You didn't do that in the trial court or here.
Correct, Your Honor. We have been asking to basically purchase her 9.89 years, give her the right, the constitutional right that she has to purchase 9.89 years at the prices they were given when she requested it in 2012.
Isn't the fact that she has, I'm sorry, did I?
No, go ahead.
Isn't the fact that she has to elect to purchase the credits an indication that she doesn't have an absolute contractual privilege to assert a vested interest in that? I mean, she has to elect to do it, and she has to pay a price, and in exchange for the price, she reserves certain credits. But that's a contract aside apart from her employment, is it not? Is it not just a benefit under statute that she can, or maybe doesn't necessarily have to, participate in?
Your Honor, I believe the case law that's out there says that it vests immediately upon acceptance of employment, and that we're talking about two different contracts. ASRS is talking about the actual purchase at the end of the day. We are talking about the right to be able to purchase is absolute. Anytime she so chooses to elect that right and go in there.
Absolute. Is it, as Judge Winthrop suggests, it's modified over time? She has an absolute right to participate in whatever it is over time?
It can't be modified to her detriment over time. That when she enters the employment in 1984, and benefits are allowed in under the case of Thurston that it talks about presumption of acceptance, if it's a beneficial amendment, it's allowed in, but it's not allowed to detriment her at all or impair or diminish her rights. So at the time she enters an employment, and then in 1996, when this statute that was in play until 2012 or 2011, when the new statute that we're talking about came into place, it allowed her to purchase unlimited service credit. So she was able to determine any time she wanted to. At that point, that becomes part of the contract, and any time she wants to, up until retirement, she has the right to purchase those service credits.
But if she elects to do nothing, then she's lost nothing under her contract at retirement.
Well, if she likes to do nothing up until the point of retirement, she still has that right to purchase service credits. But yes, Your Honor, you're right. At that point, if she decides not to take it, she doesn't take it.
She also has the right to collect that, it's almost 10 years, we'll call it 10 years for sake of discussion, but she has the right to collect that 10 years from Minnesota, doesn't she?
She has some right to collect some of those benefits, Judge Roscoe, but the problem is it's not the same value as I understand it. So if she was to retire, based on the calculations that were given to us, something like $3,700 a month, without taking anything out, it's something, if we had to not get a chance to purchase those service credit back, it would be about $1,600. And then to take the Minnesota credits, it's still something smaller than that delta.
I'm not talking about the Minnesota credits. What I'm talking about is the Minnesota retirement. She can retire from, can she not retire from Minnesota and take that money So in other words, have two retirements, one from Arizona for whatever it is with for the 20 years, and then the 10 years that she has from Minnesota. So couldn't she, so she hasn't really lost anything, has she?
Well, the value, the payment that she would be getting, I believe, would be much less, even in that context, because you're dealing with multipliers on both levels. So you're dealing with basically early retirement in Arizona, which is what it would be a much less multiplier, some in the magnitude of $2,000, let's say. And then you'd be getting some money back from Minnesota, but not nearly that amount.
Well,
So
I'm sorry, what you're talking about is, it's a timing issue. Your numbers are predicated on an assumption that she wants to retire now as opposed to working the full 20 years, if that's the number, in Arizona and combining it with her Minnesota.
Well, at Miss Pendergast's age, Your Honor, she has, we're at the rule of 80, the rule of 80 that people know about. It's the years in service credit to work. So she's worked 30 years. She should be able to get those 10 from Minnesota and the 20 she's worked in Arizona, plus her age, and she should be able to retire if she so chooses.
I understand your point. I was just saying that your numbers, in answering Judge Orozco's question, on the difference in the value is predicated upon an assumption that she's taking early retirement in Arizona.
Well, it's predicated on two things. Either she gets to retire now for the full amount, and she's allowed the amount that she's entitled to under the ASRS contract, as I refer to it, or she has to work another 2.5 years to get that same benefit. But either way, the benefit, we're talking about the two most sacred rights of retirement: the amount of money you're going to receive, and when you could retire fully. And so she can't do either at this point based on the actions by ASRS. If she retires now, she gets less. It's just as simple as that. Or she has to work another 2.5 years to get that same amount.
Are you saying that the legislature couldn't change the timing of retirement? I'm not talking about the amount.
So, like, you need to get to the retirement at the age of Rule of 85?
Yeah.
I would argue they probably could not, Your Honor. But, I mean, we're not here today for that. But I would argue that is one of the most sacred rights we have. I don't think they can do that. I think case after case, both in Arizona, New York, and Illinois, which we've briefed extensively, they all suggest that all these rights, these retirement rights, these bundle of rights, vest upon employment. They can be increased, but they can never be taken away.
Even all these, what counsel has characterized as other ancillary programs, the long-term disability, the disability pension, the employee health insurance, the optional defined contribution plan, in your view, under your theory, all of those are sacred and contractual and protected by the Constitution.
Well, Your Honor, I don't want to go through I didn't go through the analysis of each one of those programs. That was even briefed. There was one mention or two of these programs, but I will say couple things. First, there's not a single case anywhere in the country that suggests the right to purchase service credit is an ancillary benefit, an ancillary program. However, there are cases, both in Illinois, the Buttle case, directly on point with this same constitutional provision that holds the exact same way we're asking this court to hold. Is on point. And then secondarily, the Norton case in Arizona, while it's about reinstatement of the member, it talks specifically at the end of it about they're entitled to service credits. So there are two cases, one in Arizona and one in Illinois, that talk specifically about it. Plus, it's not accurate to say this is all about deferred compensation necessarily. That's the fundamental right we're all talking about.
And didn't the statute at issue in that case say that those service credits would be reinstated if the employee reapplied within the 2 years?
Yes, Your Honor. But it did say that they're entitled to service credits if they reapply. The cases that I think we're talking about conditions. I mean, I know that's the ASRS's opinion. They call these contingencies. It vests on a contingency being fulfilled. Case law in Arizona, including Yezel and Norton. Let me get there, Your Honor. Yezel says, Your Honor, about contingencies, about conditional rights in the retirement right context. We're not talking about other public benefits. It's possible in your scenario, Your Honor, talking about public health and other scenarios. We're talking about other rights that are differentiated from the retirement benefits. So I would have to do the analysis. I can tell you that Yezel says specifically, quote, that an applicant for retirement may not earn the right to benefits because he does not perform the condition does not mean that from the moment of entrance into employment, there's not a firm binding contract. Additionally, the Donner case in New York, Donner was about the right to re-enter the retirement system if the member was rehired. The court found, quote, this opportunity to re-enter the retirement system while conditional upon being rehired by the city was nevertheless a retirement benefit. The court found there to be a fundamental principle that a benefit may be conditional and still be constitutionally protected. So in other words, the right is absolute. Just because there's a condition in place, if I ever meet that condition, if Ms. Pendergast ever meets that condition, she's able to go ahead and purchase. So there are two rights we're talking about. It's a contractual right under the ASRS contract to have her right to purchase the service credit when she so chooses. Then obviously, when it gets to that point, she can't get the right. She can't actually exercise until she pays it. But it doesn't mean that we need to get to that point before that right can't be infringed upon. That's what the Buttle case says specifically when we're dealing with military service credits. It's wholly on point. Any other questions?
I'm sure there are.
Okay.
Go ahead.
You know, we believe the law is clear. We believe it's clear under three different contexts. We got the Constitution of Arizona. We've got the Illinois and New York case law directly interpreting constitutional provisions there that are identical to Arizona's, and we got 50 years of Arizona case law. This is not an absurd result that ASRS wants it to believe. The plain language says it under the Constitution, the membership in a public retirement system is a contractual relationship subject to the Contracts Clause. And then it goes on saying public system retirement benefits shall not be diminished or impaired. The right to unlimited service credit is one of those rights. It's just part of the bundle of rights. It's somewhat simple, at least the way I'm viewing it, as a bundle of that right that they can't impair. We talked about the cases in Illinois, but the holdings there and in New York, first holding, all retirement benefits vest when a member enters the system or at a date at the constitutional amendment is effective, whichever is later. The second holding from the Buttle case directly is the right to purchase service credit. What we're talking about here is a retirement benefit like all other rights that's constitutionally protected. And lastly, the member need not actually purchase the service credit for it to be protected. They don't need to do anything else to avail itself of that protection. Arizona cases are also directly on point. 50 years of Arizona cases that aren't absurd and haven't been really addressed directly in this context by ASRS. A contractual relationship for the retirement benefit rights exists between the member and the state from the moment of employment. Those are the rights that can be relied upon, and those are the rights that can't be infringed.
Counsel?
Yes. Right.
What would be the effect if your client could purchase the 5 years that the statute allows? Could she retire? Would she have her 80 points?
No, Your Honor. She would have, I think it would be 75.81, at least as the time we briefed it. I think that was the points I calculated. And so she'd have to work 5 more years, or 2 more years, 2.5 more years, because you get age and credit. So that was taking an assumption that she could buy back all 5 years, the calculation under the brief.
Okay, that's what I was curious about. Okay, thank you. Go ahead.
Yes. You know, every case in Arizona that's followed the Ezell has held the same thing. In the retirement rights context, in the retirement benefits context, it vests upon acceptance of employment. Other public employment, other benefits in the public employment world, sick leave, annual pay, vacation accrual, those things might not vest. Those things might vest upon satisfaction and performance. But every case stands for the retirement benefits vest upon employment.
Does it vest on the date of employment? Does it vest when they become members of the system? Is that the same date?
Well, I think so. Your Honor, in this case, I believe it's relatively the same day. I mean, that cases are talking about acceptance of employment or becoming a member kind of congruently.
Of course, when Ms. Pendergast became a member, this program didn't exist.
Correct, Your Honor. And then in 1987, it did exist. And then in 1996, it existed for unlimited rights. In the Thurston case, directly on point with this issue, says that when you have a benefit that increases your benefits, that automatically becomes part. And the consideration for that is your continued employment. Other case law in both jurisdictions talk about that.
Does the fact that she discontinued her employment in Arizona change that analysis at all? Because she discontinued it and went to Minnesota.
I don't believe so, Your Honor. I think it would be the same thing as the reinstatement cases. It would be that because she never discontinued her membership, let's be clear. She was an active member, and the whole point is you could go to one place, work there, and then come back and bring it. I don't think it matters if she started in the Army, let's say, and working as a public official, and then bringing it over, or if she's gone back and forth. She remained a member all 30 years of her career. She just became a different member. Our view of this is that just like the state can't increase the retirement age, decrease monthly payments, change the eligibility requirements for membership, change the percentage of contribution an employee must pay, or change the right of a member to be reinstated, they can't change the amount of years someone could purchase back. That is a right under the statute that's part of the bundle of rights that we're talking about, the ASRS contract that the case law makes clear is available to our clients. To us, Your Honor, the ASRS here is taking a puzzling position in our view. The ASRS claims that the service credit is some ancillary program that's never been determined ever. It's instead, the case law on this is clear. Buttle is clear. The Illinois constitutional cases are clear. The New York constitutional cases are clear. Rights like this are vested rights upon acceptance of employment. They're no different than the right to retire, the age requirement or the contribution requirement. All cases that are being decided as we speak. Our view is, Your Honor, that if she continues to not be allowed to purchase, she'll have to work another 2.5 years or get a lesser right. And we believe that the Superior Court got it right when they determined that these are sacred rights. The right to purchase service credit is a sacred right. It's a vested right and contractually constitutional right that cannot be impaired. In doing so, it would be unconstitutional. So we ask this court to affirm the Superior Court's decision and reverse ASRS's decision adopting the ALJ recommendation, order that Ms. Pendergast be allowed to purchase all of her service credits if and when she decides to do so, and neither that the ASRS nor the state can interfere with that right, and third, award her attorney's fees and costs as a result of this appeal. If you have any questions, I'm running out of time, but I'm happy to answer.
No.
Thank you.
Thank you very much, Counsel.
I have a few comments I'd like to make. They're not necessarily organized, but hopefully you'll understand them. Number one, if employment is considered consideration for not only the core retirement benefits, but all these other programs, then the effect is that for an entire generation of retirement membership, the legislature and the fiduciaries of that plan can do nothing to make changes to the plan. Now, Mr. Lang commented that the service purchase program became unlimited in 1996, and that's correct. But that brought to mind a comment made in the Baker versus Arizona Department of Revenue case, where the court commented it was unrealistic for the plaintiffs to believe that this program would continue. The offer was $30,000 for the state to pay for a used motor vehicle of $6,000. The same is true here. For members of the retirement system who were already on notice that this program had been modified several times, to think that they could continue purchasing unlimited number of years of service, and there have been instances where people bought 30 years, is just not sound. One of the comments, I believe it was Judge Winthrop made, was it is correct. Nothing has been lost. The employment services that Ms. Pendergast has provided to the state of Arizona are intact. That has not been diminished. The employment services that Ms. Pendergast has provided in the state of Minnesota is also intact. She's entitled to receive exactly what she was promised by those two states for the employment services provided. Now, I disagree with Mr. Lang. I don't believe that Arizona case law supports that these are absolutely rights that can't be modified. For example, service purchase. All the cases address the core bundle of rights, which is a monthly pension, the survivor benefits, and refunds. In fact, the fund manager case which addresses disability pension, even notes that for a pension right, some of those pension rights are ancillary, or contingent upon an event happening, and in particular that event was a disability. The same should be true for these other programs, that they're contingent upon a particular event happening. And that
Can, as counsel suggests, that benefit be both contingent and vested?
no, Your Honor, I disagree. I believe it must be one or the other.
You do know what I'm talking about. He said it vested, the right to those credits vested at the time of employment. You're saying no, they are purely contingent,
Yes, Your Honor.
and they're contingent upon
Payment.
subsequent contract entered into between the parties for a benefit that's authorized by the legislature if they choose to participate in it.
That's correct.
Thank you.
The other comment on, it's incorrect that Buttle is the only case on service purchase. There is an Ohio case that I provided in the brief that follows a more rational analysis used in Arizona case law on what is considered a vested right. Basically, that the individual needs to take some action to vest that right. Now, the Norton case, first of all, that case was involving a core retirement benefit, which is a refund. And what the judge already pointed out, which is true, is there was no issue in that case because the statute in place at the time of employment, at the time of refund, and at the time of reinstatement was identical. It permitted an individual who returned to employment within 2 years to get those credits back. So that court never had to decide if the legislature had modified that program, would the plaintiff still have been entitled to that right? That wasn't addressed. Now, a comment on Article 29, the publicity pamphlet. It was clear in that material that the parties, the voters intended that adoption of Article 29 to be consistent with current law. There's an important distinction here. In Arizona, from 1965, Arizona had already recognized that core pension rights, that monthly benefit, is contractual. In New York and Illinois, they waited until their constitutional amendments were adopted to move from a gratuity theory to a contract theory. So the analysis for Arizona is not identical to the analysis provided by Illinois and New York on the relevance of the adoption of the constitutional provision. In conclusion, what I'd like to leave you with is the following. None of these states have a definition for what a retirement benefit is in analyzing what is protected and what is not under their constitutional provision. New York and Illinois clearly chose to take an arguably overreaching interpretation of what is protected. Illinois in the Buttle case reveals that it decided everything in the pension code is protected, including the service purchase program. I would contend that those decisions in New York and Illinois have led to the current state of public pension plans in those states, which is basically leaving them in a very limited opportunity to make any meaningful changes to those plans to operate them in a responsible manner. Arizona has the opportunity and should take it to interpret Article 29 of the Arizona Constitution in a narrow, meaningful, and most importantly, sustainable manner as the voters intended. Thank you.
Thank you, counsel. Very interesting arguments. We will take this matter under advisement and issue a ruling in due course. We are going to adjourn briefly and allow the next argument to come forward, and then we will do that.